Bismillah Rahman Rahim. Today is 14th of January 2026. Topic of today's vlog is alcoholic drinks are intoxicating liquor. In Pakistan, under enforcement of Hudud Ordinance 1979, the use, transportation, sale, and manufacturing of alcoholic liquids is prohibited. It's an offense and which can be tried in the magistrate court, and accordingly the punishment is announced. But we have the two different situations in this case. For Muslims, we have the different situation, and for the non-Muslim, we have the limited exception. What limited exception exists is that if somebody is having license to use, so he can use, and he can use the liquor, he can use the alcoholic drinks. But for Muslims, there is no exception. He has to face the law. There is two articles, Article 3 and Article 4, are relevant for the use, manufacturing, sale, and transportation of these alcoholic drinks. In case of Muslim, when we say a Muslim is caught by using this alcoholic drinks, I mean the consumption and drinking is more serious, and it comes under had. And as per had, if somebody is proved that he has consumed the alcoholic drinks, and if he is Muslim under the had, he will be given 80 lashes, and it is only for the consumption. But in all other cases, we have the different punishments. But in case of a non-Muslim, the exception is that for non-Muslims, the Pakistani law, I mean the Islamic law and the enforcement of Hudud Ordinance 1979 is not applied. Instead, Tazir is applied. And for Tazir, if someone is caught for all these four acts, so there is 2 years maximum, up to 2 years punishment, and there is some fine, or both punishment and imprisonment can be awarded by the magistrate. So this is what is important. The exception is for the non-Muslims, and for the Muslims, if he is found carrying, transportation, or selling, etc., of course, it comes also under Tazir, and he will be given up to 2 years imprisonment, fine, or both the punishments can be awarded. But in case of consumption, the use of alcoholic drinks, had is applied, and that is 80 lashes to be given to the person who is found guilty of using or consuming alcoholic drinks. Today, I got an opportunity to cross-examine an investigation officer. There was a non-Muslim, he was a Christian, he was caught up by carrying 2 bottles of this intoxicating liquor. And his case was brought before the magistrate, and it reaches up to the cross-examination. And when I was asked to cross-examine the IO, I asked him, "Sir, how much liquor was there in the bottles?" There were 2 bottles. He was blamed to carry 2 bottles, in possession of 2 bottles. When I asked him how many milliliters were there in the bottles, whether big bottles or small bottles? He was unable to answer because he could not see the quantity inside. And when he was asked that which type, which company, manufacturing company of the this intoxicating liquid was, so he was even unable to give us the proper name of the this alcoholic drinks bottle. Then he was asked that when you caught up this gentleman accused, have you endorsed some civilian witnesses with here, or it's just police challan and caught up by the police without any private or any private witness? So he said, no, sir, there is no private witness. So this is how the things go weak when you do not have the private witness, and you depend and you prepare a case with such witnesses which are uniform personnel, I mean from the police. So here the things go weak. And when you do not know which type of, what is the name of the company, of manufacturing company of these alcoholic drinks, again, this is another weak point. And when he was asked that how much liquid was inside, what are, I mean, the contents, the quantity of the contents inside the bottle, how much milliliters? So he was answerless. So it is how the things go weak from the prosecution side when the prosecution does not have the full detail while submitting challan and investigation, while carrying investigation. They do not care, and when they do not care, they are unable to give proper answer to the counsel of the accused while in cross-examination. So the magistrate has suspended, I mean, the magistrate has given another date to announce the verdict, but it shows, it is expected that this case will be dismissed, and because the prosecution does not have the strong evidences, and it was not properly and securely investigated case. So the thing is that the prosecution must have very strong evidences to get the punishment of an accused. Otherwise, the things will go unnecessarily wastage of time and efforts. So that's what we need to take care, that things, we need to bring the things up to the required level, bring the investigation up to the required level, so that the criminals get punishment. That's all. Thank you very much. Bye bye.